Good afternoon. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and I'm a bit scatterbrained today, so I apologize for that in advance. We'll get to the JRC in a moment, and yes, we're looking at the JRC attempting another lawsuit and getting shut down so brilliantly in the shortest government document I have ever read in my life. But before we do, real quick, if you're unfamiliar with the Stop the Shocks campaign or the campaign against the troubled teen industry, all pertinent links are going to be right there for you in the description box. Should you like to do a deep dive on either topic, you should definitely be able to go ahead and do so. Trigger warning, this channel is marked not for kids for a reason. I do use profanity. And when we talk about places like the Judge Rotenberg Educational Center, you're going to hear vivid descriptions of and catch clips of surveillance footage of people's mental health issues and disabled people being tortured and abused. So if you have a child that is 16 and younger and they are watching this, parental supervision is very much advised. So this was the Judge Rotenberg Educational Center versus the FDA again. Now this was back early last year, February 25th of 2025, but I decided to go ahead and go through it anyways because holy shit, the FDA did not hold back. The government did not hold back. For once. Now, if we can get a federal investigation into that facility, that would be great. God knows I'm not dependent on this current administration for that. They want to put us on farms to work for free while they take away our freaking meds. I feel like the Hulk. You're really not gonna like me off my meds. I promise. Alright, so, request for records concerning proposed rule banning graduated electronic decelerator. Disposition granting defendant's motion for summary judgment, denying plaintiff's cross motion for summary judgment. In other words, what do you mean cross-examination? We are not prosecuting a crime here. This has to do very specifically with your device. What are you even talking about? Thank you! Finally someone saying it other than me. It's just... what are you gonna do? Cross-examine the device? It's not a criminal case. I can't with these people. The stupid, it physically hurts. Not kidding. Alright, we're going to start with bullet point 1, which means it's going to be a relatively short vid. I say, famous last words. Litigation considerations, adequacy of search, exemption 4, exemption 6, litigation considerations, evidentiary showing, reasonable severable showing. The court holds that the plaintiffs do not challenge defendant's motion for summary judgment as to whether defendants conducted a reasonable search for Center for Devices and Radiological Health's CDRH records, properly applied to the FOIA exemption 4 to CDRH records, properly applied FOIA exemption 6 to CDRH records, and properly evaluated CDRH records for severability. Accordingly, defendants are granted summary judgment as to those issues. So, this is just your normal summary. So just like with the original final rule, this is saying, yes, you'll get all the paperwork, right? You'll get all the paperwork, JRC. That's all we're giving you. We find your idea that, but we deserve the right to cross-examine witnesses with cold, hard evidence. What is there to cross-examine? We have your own video surveillance footage. What do you even mean? Not to mention, again, more's to pity, but this is not a criminal case. I mean, this saying is all. Now, this is a little bit long, so we're going to get into the second bullet point here, this giant paragraph. And there's going to be a whole lot of legal jargon that you and I, laymen, are probably not going to understand, but we'll try to do the best we can here. Exemption 5, foreseeable harms and other consideration. The court relates that the plaintiffs argue that the Exemption 5 does not apply to records of ultra vires actions. As a consequence, in their view, the D.C. Circuit's decision vacating the final rule because the FDA lacks statutory authority to ban the use of the GED to treat self-injurious or aggressive behavior nullifies the defendant's invocation of Exemption 5 in toto. As an initial matter, plaintiffs' characterization of the FDA's rulemaking for the final rule as consisting of ultra vires acts merely because a majority of the D.C. Circuit panel vacated this rule upon finding the FDA lacked statutory authority to ban GEDs for particular uses is a hyperbolic stretch. Thank you! Finally! No, we want to ban your device specifically. The fact that it was designed for a singular purpose is probably why the FDA worded it the way that they did originally. Again, I really wish they would have said specifically the GED to end all this confusion and not give the JRC a foot to stand on, but here we are, we gotta work with what we got, right? But thank you, sane people, because I lose hope in astronomical amounts every day. So just to find a singular sane person, I can't even describe it. The circuit's ruling that the FDA lacks statutory authority to ban GEDs for a particular use voided its ability to invoke Exemption 5 stems from a highly strained reading of a nearly 50-year-old D.C. Circuit decision in Wiseman versus the CIA. CIA! You are not law enforcement, JRC. I know you like to think that you could be if you just say so enough times, but then reality, you are not CIA. This is what I mean. The way that they defend themselves, and the fact that they get away with it in spite of it being so bad. Somebody with real actual power and authority, or several someones, has to be protecting them. It's the only thing that makes any kind of coherent sense. In Wiseman, the D.C. Circuit rejected the CIA's invocation of FOIA's Exemption 75 U.S.C. and 522b7, which shields from disclosure certain records for law enforcement purposes. Highlight that. What does that say, JRC? Does that say records for medical assistance or school records? No, it says law enforcement. Let me say it again a third time. Law enforcement. To withhold records regarding its investigation into the plaintiff, an American citizen living in the United States, to determine whether he was a safe candidate for recruitment by the agency, pointing to the language in the CIA's organic structure that specifically provided that the agency shall have no police, subpoena, law enforcement powers, or internal security functions. The court found this directive was intended, at the very least, to prohibit the CIA from conducting secret investigations of United States citizens in this country who have no connection with the agency. In other words, it has nothing to do with healthcare information. It has nothing to do with the records that the FDA may request in regards to the so-called effectiveness versus the harm of their device. It has to do with a completely different branch of law entirely. This is like that argument they used, but the scalpel. Like the difference between an apple and a diesel truck carrying 3 full-size trailers. As such, the full background check within the United States of a citizen who never had any relationship with the agency could not qualify as having law enforcement purposes. In other words, your documentation that they are asking for, that they are going over, has to do with law enforcement purposes. I wish law enforcement was looking into you the way they should be, but that's not what we're dealing with here. Consequently, the CIA would not invoke Exemption 7 to withhold the records. Bing, 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 bing. Seriously. An entirely different side of the law. Has nothing to do with this. Plaintiffs analyze Wiseman to apply the facts of this case, contending that, like the agency in Wiseman, the FDA attempted to regulate an area that the Congress has expressly and ambiguously prohibited, and that is the traditional province of the states. We're talking about the CIA. What in the holy Alex Jones tinfoil hat wearing conspiracy theorist coding, what are we even doing here? Jesus Christ. Wiseman, however, does not sweep so broadly as to swallow Exemption 5 protections, whereas here an agency conducts a statutory authorized and complete rulemaking, but reaches erroneous conclusion in a final rule based on a colorable interpretation of its organic statute, as confirmed by the divided panel of the D.C. Circuit Court. No, it is not complicated. You should not torture children. No, not if they are disabled. No, even if they have behaviors that scares you. The answer is no. And that is not medical care. The plaintiff's position falters out the gate because at issue in Wiseman was the CIA's statutory bar to satisfying Exemption 7's threshold, statutory requirement that records must be compiled for law enforcement purposes. And that is fundamentally different from Exemption 5's statutory protection for records falling within the privileges available to government agencies in civil litigation. In other words, in situations like this, when we're talking about banning a device, a law that has specifically to do with the CIA, and restrictions in regards to information they can get on U.S. citizens without proper restraints, without proper process, these are entirely two different things. It's like the JRC actually puts effort in finding the most idiotic arguments they can possibly find, and then praying that nobody notices how bad it is. I'm just saying. But we're going to go ahead and close out for this one, folks. We're going to go ahead and continue with this document a little bit later, but for now we're going to go ahead and close out. We don't get very many views on this channel, and the few we do get do tend to get removed from time to time, so please don't forget to hit the like button, hit subscribe, don't forget to hit the comments, and make sure that you are still set up to receive notifications. As well as the JRC, we're going to be continuing doing the Down the Rabbit Hole series and the Snake Oil Salesman series. We don't want you all missing anything. I do appreciate your time, and as always, folks, we here at Spilling Tea absolutely do hope you have a good one. I will see you all next time. Bye, everyone.